I'm Commissioner Regalado, and thank you for spending your lunch break with us. Today, we're talking about our constitutional partners, specifically about the property appraiser, my favorite constitutional officer, and my wonderful dad, Tomás Regalado. Thank you for joining us as we learn more about this office and how together we can help all the residents of Miami-Dade County.
Thank you, Commissioner. Thank you, Raquel. And I think it's important. We welcome this opportunity because there are several things that we should address in this educational webinar. Number one, everybody knows that for the first time in decades, there is a huge conversation in the state of Florida and other parts of the United States, but basically in the state of Florida, about property taxes. Second, the Office of the Property Appraisal was part of Miami-Dade County government. No longer is the case. In 2018, the voters of Florida amended the Constitution in order to mandate that all 67 counties will have 5 constitutional officers. As you know, that was approved in 2018 and implemented in January 7th of 2025. So we are in our first year of a freestanding office, an independent office, and that's important for everyone because we do not respond to any local government. We just respond to the people. And this conversation is because for many years, there's been an increase in values and also property taxes. In fact, in the last 2 years, property taxes increased in Miami-Dade County by 40% in regards to 3 years before. So it's an issue that has to be addressed, and it's being addressed by the state legislature. The 2 attorneys that you will be listening and seeing here we most likely will explain what is going on with the legislature and what are our priorities. The only thing I can tell you is that we found that there is a very huge divide in this community of people that don't know their rights. People don't even know who or what is a homestead exemption. We decided when we took office to take the office out of the office and bring it to the people. As of today, we've done 50 outreach in 50 locations in Miami-Dade County. In fact, today is Wednesday. Tomorrow will be in North Miami as part of our pilgrimage for around the county. And we, on these visits, that we take more than 40 of our able employees with computers, all the data, we are able to sign people that have rights that they didn't know that they have rights. So we have seen face to face 28,000 people in this tour throughout the county that will continue, and those people have been able to be signed for exemptions, different exemptions, from homestead to widows, civilian disability, veterans disability, people that are blind. There is a great number of exemptions, and these have saved the people $24 million in this year bill of taxes. We will continue on this path, but I think it's important that you all know how to approach the laws that are current now, could change because of the legislature, but, and how you can use that law to save in property taxes. Thank you so much for listening.
Great, and if you'll just allow me 1 second to start the PowerPoint.
I'll use this opportunity to say that since we're recording, it will be available on the Commissioner's YouTube afterwards, so you guys can review it later. All right. Thank you, Diana.
Thank you so much. Thank you so much, Alejandro. My name is Diana Artiaga, and I'm the General Counsel and Chief of Staff for the Property Appraiser Tomás Regalado. And just a bit of housekeeping. We have a little outline for you here of the things we're going to attempt to cover in the next hour. Please don't scramble to write everything down because, as Alejandro mentioned, this educational webinar is being recorded. So all the information will be made available on the YouTube channel, and we will again provide our contact information at the end of this presentation. If you have any individual questions about your property or about any of the topics covered today, we would be more than happy to follow up with you after today's presentation. As the property appraiser mentioned, we're currently in a legislative session that has zeroed in on some sort of reform in regards to property tax exemptions and property tax law. So just as a caveat, the presentation that you're seeing today is homestead exemption and portability laws as they stand today. We're hoping that the legislature does accomplish something during this legislative session, if not a special legislative session where many of these examples that we're giving today may change. The property appraiser mentioned the ideas that he's proposed to the legislature. So within the last year that he's been in office, in the many outreach events that he's done, in the countless people that have come to meet with him personally or with our staff, he put together a list of ideas that are the list of ideas that came from individual taxpayers and property owners in this county to advocate for fairness, for reform, for additional benefits in the homestead exemption arena and other existing benefits that the legislature has not taken a look at or reformed in many decades. So we're happy to share some of those ideas during the presentation today. And if any of you would like to follow up on some of those ideas that the property appraiser is pushing forward, he does do a great job of posting on social media about his community outreach and his advocacy. He will be in Tallahassee throughout the session advocating for those priorities that are important to property owners in Miami-Dade County. So just as a quick additional housekeeping item, the Office of the Property Appraiser is regulated by Florida statute. We're going to be citing various statutes in here that guide everything that we do in this office. We're also regulated by the Florida Department of Revenue, the rules that are promulgated by the Florida Department of Revenue. We're also audited annually by the Florida Department of Revenue. So many of the functions that we do on a day-to-day basis in this office are ministerial. So with that, we'll go to the first slide. What is a homestead exemption? Many of you may know, but for those who don't know, a homestead exemption from ad valorem taxation is a property tax benefit that can save homeowners up to $50,000 of the taxable value on your primary residence. That means the first $25,000 applies to all taxing authorities, and the second $25,000 excludes school board taxes. This second exemption, starting last year, will adjust based on the Consumer Price Index. For those of you who don't know, the Consumer Price Index is given to us yearly by the Florida Department of Revenue. And just as a clarification, for those who might not know the distinction between ad valorem and non-ad valorem, today we're focusing on just ad valorem taxes, which are taxes based on the value of your home. This is different from non-ad valorem taxes, which are generally fixed fees that are added to your tax bill, such as solid waste. So let's move on to how do you qualify for a homestead exemption? And again, this is all directly from Florida statute. The property owner must have quote unquote legal and equitable title. We'll define what that is in a subsequent slide. As of January 1, and that is an important date. So if you purchase a home and you reside in a home after Jan 1, you would not qualify for homestead exemption until the following calendar year. Permanent residence on the property is also another qualification, as of Jan 1. And the property owner or others legally or naturally dependent upon the owner have to be a U.S. citizen or permanent U.S. resident. We'll get into these in the subsequent slides. So what is legal or equitable title? State statute defines that as the person having a possessory right in such real property based upon an instrument granting him or her beneficial interest for life. The property may be held in a trust if that's, based on your conversations with your attorney. You feel that a trust is beneficial for your property and your structure. It may be held in the trust if the terms of the trust meet the requirement above, that the person has a possessory right and legal and equitable title. How do you demonstrate permanent residence? So when you come to our office and you submit your application, or you do it online, you submit your application for homestead exemption, you have to provide proof of permanent residence. And that can be proven by a valid Florida driver's license, vehicle registration, or any of the other items that are listed on this slide. How do you apply for homestead exemption? So there is a form provided by the Florida Department of Revenue that you would fill out. And again, if this is your first time around, or you have any questions on how to fill out or complete the application, I've shared some information here. Our website is miamidadepa.gov. You can go and apply online. And the great thing about applying online is that you can track the status of your application. This is how you navigate directly to the online application tool. But again, when in doubt, if you have any questions, please go to our website. You can schedule an appointment at any of our 2 locations, at the Stephen P. Clark Government Center in downtown Miami, or the South Dade Government Center located in Cutler Bay. And this is just an image of what the application looks like. There's several questions that are asked here. You can see there's a section for the actual applicant. If you are legally married, there is a section for a co-applicant spouse where you have to provide certain information about your spouse, so they are also beneficiaries of your homestead exemption. What is a late filed homestead exemption application? So homestead exemption applications are due by March 1st of every calendar year, but our office may accept them up until 25 days after the property appraiser mails your trim notice, which is usually mid-September. The applicant has to complete a form, if it's being submitted after March 1st, showing extenuating circumstances for the late filing. So you may have seen on the property appraiser's social media channel, or you may have received a letter from our office last year asking folks to come in, that there was still time to fill out your homestead exemption for late filings. So again, March 1st is the key date, but up until around September, 25 days after the property appraiser mails the trim, you can still file your homestead application.
And just to clarify, the trim notice is also the notice of proposed property taxes. And it'll say on top, this is not a bill, but that document is imperative because it lets you know what exemptions you are receiving on the property, what your valuation is for that year's assessment. And if there's any errors, if there's any concerns, that is the time to contact the property appraiser's office. And because that is also what triggers that final last push for you to apply for homestead exemption.
Correct. So once you've submitted and completed your homestead application, it's been approved by our office. What happens the subsequent year? You don't have to apply every year for homestead exemption. There is a residential renewal receipt that goes to your mailing address, and it confirms that your homestead exemption will be automatically renewed. If you still qualify for the exemptions listed on the receipt, you don't have to do anything further. But it is important, if anything changes in your exemption status, if there is a change of ownership, if the property is rented, we're going to get into these situations in a couple additional slides. If any of your circumstances have changed, there are questions on that form that need to be filled out and returned to our office. Here you can see some information. If the owner fails to notify the property appraiser of any change in status, there is a possibility that the property owner can receive a lien, and Florida statute allows property appraisers to look back 10 years, just so you're aware, of exempted taxes And that could include penalties and interest in the lien as well. So it is very important, if you see a letter come in from Tomás Regalado, Property Appraiser of Miami-Dade County, that you read the entire letter and the entire form. And again, if you have any questions or concerns, you can always reach out to our office and we can provide you with additional information. So common pitfalls. We wanted to put together a list of slides on issues that we see taxpayers commonly run into. So hopefully none of you fall into these pitfalls in the future. So you're no longer eligible for homestead exemption if, and I mentioned a few of these a little earlier, if the property becomes rented or it's no longer your permanent residence. If you no longer have legal or equitable title. If you no longer are a permanent resident of Florida, or if you or your spouse begin to receive a homestead exemption on another property. A family unit is only entitled to one homestead exemption. So going through these one by one, if a property becomes rented or is no longer your permanent residence, you would not be eligible for homestead exemption. However, if you do have a partial rental of your property, you would not lose your homestead. If you rent a portion of your property, including an accessory dwelling unit, commonly referred to as ADUs, that specific portion that's being rented would not receive the homestead exemption cap savings that you accumulate year after year of having a homestead exemption. Another common pitfall, you no longer have legal or equitable title if, say for purposes of this discussion, mom and dad are still residing on the property, they have legal and equitable title, and they decide to outright deed the property to one of their children, in this scenario, their son. That is considered a change in ownership. Mom and dad would lose the homestead exemption on that property. Another common pitfall, we see this scenario come up time and time again in Miami-Dade County for some reason. Again, if you are legally married, you are only entitled to one homestead exemption, and that applies to properties outside of Miami-Dade County or outside of the state of Florida. Say for purposes of this scenario, if prior to the marriage, each of you own a separate home and you receive two different homestead exemptions. Once you get married and become one family unit, you must cancel one of the existing homestead exemptions. There's only one homestead exemption allowed under law per family unit. And at this point, I'll turn it over to Victoria to get into portability.
Thank you, Diana. So my name is Victoria Llerena. I am a senior counsel for the Property Appraiser. And I have the pleasure of going over the Save Our Homes cap with you. So what is Save Our Homes? So Save Our Homes is can amount to very large property tax savings. So the homestead exemption is $50,000, and that second homestead can be adjusted now for the CPI. But there are substantial savings that result from the Save Our Homes cap. It's the biggest advantage of having homestead on the property. So what it does is that after the first year a property receives homestead exemption, the property needs to be assessed at just value. Your market value and your assessed value need to be the same. However, in subsequent years, the assessed value of the property cannot increase more than 3% or the percent change in the consumer price index, the CPI, whichever is less. The accumulated difference between the market value and the assessed value becomes the Save Our Homes cap. And that could result in very large property tax savings where you do not pay taxes on that differential, on that amount of differential. I have seen homes, so there's property, high-end homes in Miami Beach area, in Coral Gables area that can have multi-million-dollar cap savings. So what does that mean? Let me show you an actual example here. This is a property in District 7. And this property was purchased prior to 2023. So at that point, when it's first purchased, the year after it's first purchased, and you declare homestead on the property, the market value and the assessed value are the same. I do not have a mouse here. Here we go. The market value and the assessed value are the same. However, the assessed value year to year then this is from our property search page. So you can look up your property in our property search page and you can see that if it has homestead exemption, the assessed value cannot increase more than 3% from the prior year. So the assessed value from 2024 to 2025 could not increase more than 2.9% because that was the change in consumer price index from 24 to 25. That's lower than 3%, so you go to the 2.9%. But the market value increases substantially because everyone knows that right now we're in a growing market. So the market value can increase whatever the market indicates that increase would be. And then the differential that is created between the market value and the assessed value becomes your Save Our Homes cap. That differential is what you're saving on. You do not pay property taxes on this amount of money. So there's, oh, well, so in 2025, the Save Our Homes cap, you'll see there that you're saving in property taxes $254,288. You're not paying property taxes on that amount. So in areas where you have the market value growing and growing even more substantially, and you have been living in this home for a long time, that Save Our Homes cap, that differential can grow into even larger numbers, and those are savings that accumulate. So you definitely want to value these savings. You want to make sure that you don't lose these savings. So how do we do that? So the Save Our Homes cap, you can lose it if there has been a change in status of the property. So Diana went over those earlier. So if you lose homestead exemption, that would be that there's a change in status of the property, and I'll go into a little bit further. The other way that you lose this Save Our Homes cap is if there has been a change in ownership. A change in ownership is defined in statute as any sale, foreclosure, or transfer of legal or equitable title. But there are lots of exceptions to this rule. Like any good rule, there's exceptions. So the first one that we discussed was you lose your Save Our Homes cap if there has been a change in status of the property. So like Diana stated earlier, you have rented the property, you now have a dual homestead exemption, you have abandoned that property, you moved to another one. That property is no longer your homestead property. It can no longer enjoy the benefits of the 3% cap on your assessed value. It'll now change to the non-homestead provisions where that property would be receiving a 10% cap instead of the 3% cap. And the other way that you lose the cap savings if there has been a change in ownership, meaning any sale, foreclosure, or transfer of legal or equitable title. And these rules are listed in section 193155. I'm going to go over the most common exceptions to that rule. There are more, so if there might be some more scenarios, you can visit the statute, but I'll cover now in these next slides the most common scenarios that are exceptions to the general rule that any change of ownership, any change of legal title is a reassessment of the property. What I mean by reassessment of the property is that you lose that Save Our Homes cap, and the market value and the assessed value are going to again be equal. So the first common exception is that subsequent to the change or transfer, the same person is entitled to the homestead exemption as was previously entitled, and no additional person applies for a homestead exemption on the property. The most common scenario for this would be if I own my home and then I'm doing some estate planning in my individual name, and I decide as part of my estate planning, I want to transfer the property to a trust. So in this trust, I am named as the trustee, I am named as the beneficiary. No additional person is named as a beneficiary with me. No additional person applies for homestead exemption. I can still continue to receive the benefits of the homestead exemption and my corresponding Save Our Homes cap, despite there being a change in ownership. It is an exception because I have now retained equitable ownership and no one else has applied for homestead exemption on the property. The next one is the change or transfer is by means of an instrument in which the owner is listed as both the grantor and grantee of the real property, and one or more individuals are additionally named as grantee. However, if any individual who is additionally named as a grantee applies for homestead exemption on the property, the application is considered a change of ownership. So what does this mean? So if I own a property and I want to add my daughter, if I own a property that has homestead exemption, I'm receiving homestead exemption, and I add my daughter to title. I create a deed and I create a joint tenancy through right of survivorship. We're both owners now. We are both named. I am named as Tor, now we're both named as grantee. As long as she does not apply for homestead exemption on the property, I can continue to receive the benefits of my Save Our Homes cap. My Save Our Homes cap is not lost. As long as she does not also apply for homestead exemption on the property. There is a slight workaround to that, but a lot of caveats, but there's a slight workaround to that where even if she's moving in with me and she's permanently residing on the property, she can claim homestead exemption and then I need to port my savings back in. I do caution though, because I'm going to get into later slides, that there are limitations or cap limitations to what you can port. So that scenario might work out if your Save Our Homes cap is less than $500,000. The next exception is legal or equitable title is changed or transferred between husband and wife, including a change or transfer to surviving spouse or a transfer due to a dissolution of marriage. So the first example for surviving spouse would be an example where, let's say, husband owned the property in his individual name, but husband passes and the property goes through probate. It's found that the surviving spouse, she takes title now outright. She couldn't receive homestead exemption at the front end because she didn't have legal title to it. It was the husband. But now that surviving spouse, she has obtained title to the property. As a surviving spouse under the statute, she is eligible to continue receiving her husband's Save Our Homes cap. It does not get reassessed. It is not lost. And then the other one is a similar scenario where you have a transfer due to a dissolution of marriage. So it would be, an example would be if you have a husband and wife that they own a property, they're both receiving homestead exemption on the property, but they decide to divorce and they want to each move to their own respective homes and receive homestead exemption in their own respective homes. They can carry over a percentage of their Save Our Homes cap to those new homes. It is not lost. Or if for dissolution, there's a court order that states that, let's say, one of the spouses has to ultimately receive the property, then the Save Our Homes cap can also transfer over to just that spouse that stays on property. This was one of the questions that came up in prior Q&A requests, and I want to make sure that there's a note out there for those who may be going through a divorce or any practitioners that are out there in the family law space, that they understand that the Save Our Homes cap is also an asset because they're property tax savings. It is an asset that can also be negotiated between the parties, depending on who is going to take it, or different percentages. There is a form the Department of Revenue puts forth where the parties can actually negotiate what percentage of the Save Our Homes cap each party is going to take with them and what property tax savings each party is going to take with them to their subsequent home. So I want to make sure that knowledge is out there. And then the last exception to the rule is that the transfer occurs by operation of law to the surviving spouse or minor child or children under Section 732-401. That's like a scenario where somebody owns a home and they deceased and the property is transferred to their minor children. The guardian can apply for homestead exemption for that child, and the child would be able to obtain the Save Our Homes cap savings. It does not get reassessed. However, there is additional information that we would need from the guardian for that child, just to make sure that we follow the requirements of law. So obviously, like I said it earlier, there's substantial savings from having a Save Our Homes cap. So if we move, we've been living in this house for a long time, we want to make sure that we can port this over. Did I cover? I apologize, 1 second. Want to make sure that we can port this over. How do you do that? So you have to establish a new homestead exemption within 3 years. For example, if the previous homestead exemption is abandoned March 2024, the applicant must establish the new homestead exemption by January 1, 2027. So you have 3 years to establish a new homestead, so that way you can still port those savings over. But the maximum amount that you can port right now is up to $500,000. Now, this is something that the property appraiser has been working on with the Association of Florida Property Appraisers. there are current proposals to increase that amount.
And in calculating those 3 years, if you look at the screen, it's not an exact 3 years to the date from March to March. Remember, Jan 1 is always that critical date that state statute tells us that we need to look at to establish residency. So 3 years from March 2024 would be Jan 1 of 2027.
That's what was a tricky calculation. And it used to be 2 years, it was increased to 3 years just a few years back. So how can you actually apply for PORT? Let me click over to the slide. So how can you actually apply for PORT to carry over your Save Our Homes cap to your new homestead property? You need to submit the application. The application is the Department of Revenue Form 501T. And this also needs to be submitted to us timely by March 1st, but you can still apply late. The same provision applies earlier. If you have it 25 days after the mailing of trim, then we can also accept it by then. So you would need to apply for homestead on the DR 501, and you also need to apply on the DR 501T to transfer any Save Our Homes cap savings to the new property. You can apply online through our portal, or you can schedule an appointment with our office, either here in Stephen P. Clark Government Center or in the South Dade Government Center. On the next page, I have what the application looks like. So you have an idea of what needs to be completed, the information completed. You can also port into other counties of Florida, and other counties, if you're living in another county, you can also port into Miami-Dade County. So here's an example of what I'm talking about. So in this example, it's a person who is upsizing. So what I mean by upsizing is that you're going to a home where the market value is greater than your current home. So in this example, we have a market value of $250,000 on the prior home. Your Save Our Homes cap is $100,000. That's that differential between the assessed value, which is $150,000, and your market value, $250,000. You're transferring that to a property that has a greater market value than your prior home. So you're going to a new home where the market value is $400,000. You take your savings of $100,000, your new assessed value is $300,000, because you pay taxes on the $300,000. You're not going to pay taxes on that straight transfer of $100,000. That's pretty straightforward. But when you are downsizing to a lower market value home, the calculation is a little bit different. So in this example, the prior home had a market value of $250,000. Your assessed value is $150,000. So your differential, your Save Our Homes cap, is $100,000. The assessed value, $150,000, represents 60% of the market value of that prior home. $150,000 is 60% of $250,000. In your new home, you can only transfer the differential of the same differential of 60%. You can't, it's not a straight transfer. You cannot transfer over $100,000 into your new home when you are downsizing. You need to maintain that ratio of 60%. So when you're downsizing, you're taking a ratio, the same ratio of your savings, but it's not a straight transfer of the full amount being transferred over to the new house when you're talking about a downsizing scenario. And then one of the last things that we want to make sure that we go over is because it was a question that we often get, it was a question prior to today's educational webinar, is how to qualify and how to apply for the senior citizen exemption. So the first thing is that the property owner must qualify for homestead exemption. So they must meet all the requirements that we listed earlier for homestead exemption. But in addition, the homeowner must be 65 years or older as of January 1st. And the total household adjusted gross income for everyone who resides at that property cannot exceed $38,686 in the previous year. And this is a figure that is given to us by the Florida Department of Revenue. And keep in mind that it is an entire household income that is what is looked at. In order to receive the homestead exemption, a person needs to apply with our office. The application is the same DR 501. It is the same homestead exemption application. There's a checkbox where you would also check off there that you want to receive senior exemption. In addition to making the request on the DR 501, there's another requirement to include the DR 501 SC, which is the household income sworn statement and return, where the applicant would need to affirm to us that they meet, or he or she meets, the income requirements of the household income being less than 38,686. And that would require also that the person submit to our office the Social Security 1099 forms that show either confirmation of non-filing, so we can confirm that the income requirements are met. Now we have here ways that you can contact the property appraiser's office. We have our actual physical locations. We have one downtown Miami, the Stephen P. Clark Government Center, and that's our address and telephone number for customer service. Below is for our residents down in the South Dade area, the South Dade Government Center, and phone number for them. And we have an email address, pawebmail@miamidadepa.gov, where we may be reached, and be happy to assist any questions that you might have for your particular property or any questions in general.
And again, we shared earlier as well that if you just take the time to peruse our website, we have a brand new website that we launched at the end of last year. Very user-friendly. You can see some of the resources that are on there, including the different ways that you can submit applications, our contact information, also ways that you can schedule appointments if you're planning on visiting us in person. We encourage you, if you, again, have any questions, that you please, contact us before you make any decisions on your property. One thing we'll also mention, a very great resource that we have on our website is a tax calculator tool. If you are thinking of buying a home, if you're a first-time home buyer, and you're not sure what your estimated property taxes will be after the transfer of property, you can play with that tool and see, what the estimated taxes will be. A lot of people don't realize, first-time home buyers, that the property taxes do reset when there is a transfer of ownership. So what the prior owner paid in property taxes does not reflect what you as the new homeowner will be paying. There is a bill that's being presented again this legislative session. We hope it crosses the finish line. The property appraiser is supporting it. The Association of Property Appraisers is supporting it, which will require website platforms such as Realtor.com and Zillow to put a disclosure there for potential home buyers that, hey, the property tax estimation that's listed at the bottom of this property does not accurately reflect what you will be paying should you purchase this property. We think that, disclosures are great. Informing people of their rights, as the property appraiser mentioned, is a passion of his. If you have questions about your assessed value, when you receive your trim notice, when you receive your estimated property taxes, please come in and see us. There's many resources that are at your disposal to look into whether your property is being valued justly. Or there might be things that our office was not aware of in assessing that property that could reduce or increase, depending on what you want to do with your property, the value. Please come in and see us first. Many of you may know that there is a resource available to property owners called the Value Adjustment Board. That is a resource of last resort if you can't come to an agreement with the property appraiser staff on the fair assessed value of your property. There are specific deadlines that you have to meet to contest the assessed value of your home before the Value Adjustment Board. What you have to do is essentially fill out some paperwork before the required deadlines and attend a hearing with a magistrate who is an assessor as well. And he'll hear your evidence that he or she will hear your evidence that you submitted. They'll hear the property appraiser's evidence and come to a conclusion on the fair assessed value of your property. But again, a lot of these issues, time and resources can be saved in just coming and contacting one of our staff. So with that, Alejandro, I'm not sure if you're there on the other line, but I know there's some closing remarks that your office wanted to make before we conclude.
Yes. All right. Thank you. Thank you, Diana. I was going to ask you, do you guys want to review the Q&A? Maybe pick up a couple. We still have a couple of minutes.
Sure. Can we do it on our end?
If you open the Q&A tab and you look at the
Stop sharing.
the answered, I already responded with everybody, letting them know they could email your question to you. If you pick a couple, there's a couple of ones there. If you guys have the information, if you guys want to share, great. If not, we can answer them later. Those of you who did submit the questions ahead of time and also emailed the property appraisers team, they're very responsive and they're great. So I saw some of those responses as well in the event we can't get to your queue. I'm reviewing them to see.
1 second. Okay, there was a question, place and time in North Miami tomorrow. So if you do have social media, you can see all these notices about special events in the community. If you all have Instagram, it's PA of Miami-Dade, all one word, PA of Miami-Dade. So specifically for the event in North Miami, it's going to start at 5 p.m. and it's going to run for 2 hours until 7 p.m. The location is at the North Miami Public Library. That's 835 Northeast 132nd Street. And we'll have staff there. The property appraiser himself will be there. The vice mayor for District 2, Cassandra Timothy, will be there as well. And our staff will be there to help you with homestead exemption questions, senior exemption, veterans, disability or portability questions that you may have. So again, that's January 29th from 5 to 7 p.m. at the North Miami Public Library. The next question was, are there free consultation appointments with any of your staff? So yes, there's no charge to come into our office to schedule an appointment, to call us, to email us. We can consult with you. We cannot provide you with any legal advice on what type of structure you should set up for your home, whether you'd like to do a trust or a joint tenancy with a right of survivorship or a ladybird deed. But we can give you interpretations of law of the property tax laws, how it may negatively or positively impact your assessed value. We can give you advice on how to questions you might have on filling out your exemption forms. They are very voluminous at times. It can feel overwhelming, especially if it's your first time filling one out. So yes, you can go online and schedule an appointment at any of our 2 locations, or just simply call over the phone. You take the next 2.
So the next question is, do you need to apply separately for homestead exemption and Save Our Homes? So the homestead exemption you need to apply for. Then once you have the homestead exemption, Save Our Homes cap savings is automatic from there. You do not need to apply for Save Our Homes. However, if you would like to take your Save Our Homes cap savings with you to another property,
that's portability.
You may do so, and that's called portability, and you can take your Save Our Homes cap savings up to $500,000 to your new home, and that would require a separate application. But otherwise, the Save Our Homes limitation is automatic. The next question is, for some reason, my homestead exemption fell off. I was living in my home. Do they back pay the years I wasn't given the homestead exemption?
In that scenario, if you have any specific questions related to your folio or your property, please contact our office directly. Sometimes there's other circumstances that we're not aware of that may have impacted your homestead exemption being canceled. So to Ms. Martins, who submitted that question, please reach out to our office directly and we'd be happy to follow up.
I already applied. How long does it take to be approved? If you apply online, you do receive an email from our office with preliminary notice of what you will be receiving. But the actual final decisions do not need to come out of the office until July 1st. If you were denied, a denial letter would be sent to you by July 1st, the absolute latest.
There's a question about the phone numbers. Again, the contact info. The phone number for the downtown government center location is 305-375-4712. The phone number for the South Dade Government Center is 305-232-3810. And there's another question about the website address. It's Miami-Dade, all one word, PA as in property appraiser.gov.
So I'll take this next question. In reference to long-term resident senior exemption, it states owning a home with a market value of less than $250,000 only applies to the first year. Please explain what market value means. So the market value is synonymous with the just value, and what that means is just what market indicates. So when I showed earlier on the chart from our public search page, the market value and the assessed value, what they're talking about there is the market value. So the market value of that home cannot exceed $250,000. This is actually something that the property appraisers, especially Mr. Regalado, have been working on changing, because in this market, there are very few homes that are $250,000 or less. So there's very few long-term senior residents who are qualifying at this point, because just the market is what the market is. So we expect that there will be proposals to change that value in the upcoming years, but currently that's what the market value means.
And market value again means what a reasonable buyer would pay for a similar property, as evidenced by sales in the area, sales of comparable properties. There's a whole methodology that appraisers go through in order to establish market value for a particular property of a similar size. Again, if you have questions about portability, agricultural exemptions, you can contact us through any of the ways that I shared previously. There's not a particular person and phone number, but just call our general line and we'd be happy to direct you to the right person to give you the information that you might need.
I think we need a bit more information on my mother-in-law passed away and the home was in Homestead. The house was in a trust with my mother-in-law with her handicapped son. My wife has the house in a trust now. Would the home still be in Homestead exempt, eligible for Homestead exemption? I think we would need a little bit more information. It also depends. You have to make sure that the terms of the trust itself grant the surviving or the successor beneficiary the rights to Homestead exemption. And I'm not sure who the applicant there is and where everybody's permanently residing. So if you can please contact us directly with more information.
And again, for those who submitted a question prior to District 7, prior to today's webinar, we will be following up individually with you to give you an answer. And for those who did not have the time or the opportunity to submit a question in advance, please contact us. We'd be happy to assist you in any way that we can.